Just to let you know, we will record this seminar, but only the presentation part. And so if you would not like to be in the recording, just keep your video turned off. And then once the discussion starts, we will stop the recording. So welcome everyone to the fourth session of the Oxford Future of Professionals seminar series. It's great to have you here. My name is Julian Korsch. I'm a PhD student in management at Said Business School. And together with Mari Sacco, Professor of Management Studies at Said Business School, we are co-convening this seminar series. And this year's thematic focus is on responsible AI. And we're delighted to have Ignacio Cofone as our presenter today. And Ignacio is the Professor of Law and Regulation of AI at the University of Oxford Faculty of Law and the Institute for Ethics in AI. He's also an affiliated fellow at the Yale Information Society Project. Ignacio's research examines how the law can and should adapt to social and economic changes driven by data and AI. His recent book, The Privacy Fallacy, Harm and Power in the Information Economy, argues that AI requires restructuring privacy and data protection law because the current forms of control have become ineffective. His current research focuses on how to prevent and redress immaterial AI harms and on regulatory design that fosters human-centered AI. Ignacio obtained doctorates from Yale Law School, from Hamburg University and Erasmus University Rotterdam, as well as common law and civil law degrees. It is our great pleasure to have Ignacio with us today. And the seminar will be structured as follows. Ignacio will present for 35 to 45 minutes, and then we will have a 30 to 40-minute discussion. Ignacio will present without interruptions, but after his presentation, as always, you have the opportunity to please raise your hand and ask your questions or offer your comments. Without further ado, over to you, Ignacio. Thank you so much for presenting today.
Thank you very much, Julian, for the very kind introduction. And also, Marie and Julian, thank you for the invitation. I'm happy to be here to chat about this project with you. And I want to use the opportunity to talk about this project together with Catherine Strandberg at NYU that covers a couple of papers on algorithmic opacity. I'll be happy to discuss in the Q&A anything that you're interested in, but I thought I would start with an overview of the project in general and diving into one of the papers. So the context of the project is the question of AI transparency and deliberate opacity. So why transparency? Well, transparency has been the topic of extensive discussion in the literature, where it is considered valuable to have some mechanisms of transparency for AI, particularly, but not only for AI decision making. And this is both for intrinsic and instrumental reasons. The intrinsic reasons are due process. People sometimes, when they're being subject to decisions, have the right to have some sort of knowledge about how the decision took place, and justification for similar reasons. And the instrumental reasons for transparency are that it may and often does aid in the pursuit of accuracy and the reduction of bias. Now, disclosure, which is what we focus on, of certain elements of a decision-making algorithm, or in a different context, it could even be an AI agent, is not a transparency panacea. But it does work as part of the accountability tool that is explanation, and it's the lowest possible form of due process and justification that explanation requires. So while disclosure doesn't satisfy all the normative desires that we sometimes have of AI transparency, it is a necessary requirement of most transparency mechanisms. Now, that said, there are a number of rationales for non-disclosure in industry and in policymaking. The first one is technical inscrutability, which is not the focus of our project. What does technical inscrutability mean? It means that sometimes certain types of machine learning systems are used where not everything can be explained. There's a very interesting discussion, for example, about whether a decision-making process like that can produce counterfactual explanations. That is not the focus of our paper or of our project. We focus rather on deliberate opacity. What do we mean by deliberate opacity? We focus on in which context something can be technically explained, but decision makers choose not to explain it, or policymakers believe that they should not be explained or disclosed, and that is usually justified for one of two reasons. The first reason under which this is justified is trade secrecy, under the argument that if there's a certain type of disclosure, then there's a loss of trade secrecy for private actors, and then they would have no incentives to innovate if their inventions are not protected by trade secrets. And the second reason is that decision subjects, if information is disclosed, will game the system. Gaming meaning that they will obtain an unfair advantage, and that gaming will lead to a loss of decision accuracy, which is also undesirable. So in prior work, we focused on these two reasons not to disclose, and we define the scope in which they are applicable, or they are reasonable, or they're plausible. So trade secrecy, for example, has the goal of incentivizing innovation, a desirable innovation, through market exclusivity. On the one hand, it is beneficial because it incentivizes innovation. On the other hand, it is socially costly. It's first of all socially costly because it reduces competition, it reduces follow-on innovation, and for the decision maker or the algorithmic designer themselves, it reduces incentives for quality improvement, partly because of this lack of competition. It is a plausible justification in many contexts. Its limitations is that government developers don't need market incentives to develop these systems, and some commercial developments could be given under other forms of IP, other forms of recoup for their investments. So the bottom line of the prior work on trade secrecy is that the trade secrecy justification is in principle valid, but it has a much more limited scope that is often argued. And I'm going fast through these objections to get to the other point, but I'm happy to talk more about them during the Q&A. So the second objection, which is perhaps slightly more widespread than the trade secrecy one, is that decision subjects, if information is disclosed, will game the system. What does gaming mean here? Gaming means influencing the output of an AI system to receive an inappropriately favorable decision. So if we have a setup where we have true positive decisions, false positive decisions, true negative decision, and false negative decisions, where just defined in any sort of way, true in that context is deserved and positive is beneficial. So a true positive, for example, would be someone getting hired who deserves getting hired, and a false negative would be someone not getting hired who did deserve to be hired. Gaming would mean moving from a true negative treatment to a true positive treatment. So, for example, in recidivism assessment, a common context in which this argument is made, a true positive means releasing people that will not recidivate if released. Recidivism assessments are AI used in the criminal justice system, such as Compass developed by Northpoint, where there's an AI assisting parole boards or judges making decisions about whether to release or not release someone under parole or bail. And usually, the reasons not to release someone under parole or bail is if they will commit another crime during the time that they were released, that they could have not been released otherwise. And these algorithms classify people as high risk or low risk regarding recidivism. So a true positive in this case would be to release someone who does not recidivate during the time that they could have been kept but are released. A true negative is to retain someone who will. A false positive is to release someone who does recidivate in the end. And a false negative is to retain someone who would not have recidivated. Green is desirable outcome, red is non-desirable outcome. And gaming in this case is when a recidivist acts strategically to get released. So they move here from a true negative to a false positive. So gaming, as you can see, is a legitimate reason for which one may want from a policy perspective not to disclose certain types of information when indeed it leads to a loss of accuracy because decision subjects in consequential decisions move to true negatives to false positives. However, the scope of gaming is much narrower than usually argued. There are three requirements, we argue, for gaming to be possible at all. And outside of these three requirements, gaming should not be a reason not to disclose elements of a decision-making system. The first requirement for gaming is that the proxies used are somewhat imperfect. So they give some sort of wiggle room for people to make certain choices that will affect their outcome without actually changing the deservedness of their outcome. A second requirement is that the disclosed content pertains to actually modifiable features, and that modifying those features is not totally costly because if information is disclosed about features that are not modifiable, then decision subjects cannot game. And the third requirement is that modifying those features is actually gaming, so that it doesn't improve legibility and it does not correct bias or errors. For example, if the algorithm being discussed is a credit scoring algorithm, where people receive a certain number that indicates the likelihood that they have to return loans, and we have a concern about whether people may game the system, well, the only thing that people can game are things that they can change about themselves. So if one feature that we disclose is that educational level is correlated with payback, for example, people cannot change their educational level to game the system in some sort of way. So that should not be concerning in terms of gaming. If we disclose something that is so closely tied to their actual deservedness, then they would also not be able to change without changing their actual deservedness. Saying, for example, that people that always pay their debts on time receive a higher credit score is not particularly concerning, because if anyone starts paying all their debts on time to have a better credit score, then they would not be gaming the system. They would actually deserve the higher credit score. And so there are a constrained number of situations, particularly related to enforcement, but not exclusively, in which gaming is actually a concern and could justify lack of disclosure. But by telling you about the limited scope of the trade secrecy concerns and the gaming concerns, I have been escaping the most difficult and possibly the most important question, which is, what do we do when gaming or trade secrecy concerns are real? What do we do when, in fact, there is a social concern that people may game the system in a certain decision-making algorithm, or that they may lose trade secrecy if they disclose all of the information? Does that mean that gaming or trade secrecy would trump everything else? Does it mean that we should disclose nothing? Does it mean that we should still disclose everything and suffer the cost of gaming or trade secrecy? We propose framing this question in terms of principal agent problems and in terms of phased disclosure. So what does it mean to frame it in terms of principal agent problems? Um, we start from the point of view that AI developers are, with varying degrees, agents of the public. Them being agents of the public means that, like in a principal agent problem, where there's an agent making decisions on behalf of the principal, and the decisions of the agent affect the well-being of the principal, designers of decision-making algorithms that are used for public purposes affect the well-being of society on whom those decision-making processes are applied. This is most obvious for government entities that apply publicly developed or privately developed algorithms, but it's also true of private actors in regulated industries or in regulated aspects of certain industries. For example, employers have duties of non-discrimination, and those are public duties that relate to corrective justice and distributive justice. So while employers are private actors, and the decisions related to who they hire are private decisions, they do have public elements in terms of their compliance with non-discrimination and their compliance of non-discrimination. falls part of this principal agent problem. Now, principal agent problems exist because the agent has limited information to audit or to verify the actions of the agent. The principal cannot see everything that the agent does, and therefore the principal cannot discipline the agent. So principal agent problems exist partly due to an information asymmetry problem. And the information providing function of disclosure precisely reduces the extent of this principal agent problem. It first of all helps detect in which cases there is a principal agent problem, in which cases there is actually a lack of alignment in incentives, and it helps mitigate it. So by framing the problem in this way, what this does is it gives an additional reason for disclosure, together with the intrinsic reasons of due process and the instrumental reasons of accuracy or bias. There's another instrumental reason that one ought to consider, which is that many forms of disclosure reduce and identify situations of principal agent problems between society and private designers of decision-making systems. So there's an extra value in disclosing when these principal agent problems are present. Why is there a principal agent problem? Well, economists tend to separate between shirking and expropriation in principal agent problems, where shirking are contexts where the agent has incentives to put lower amounts of effort than optimal in acting on behalf of the principal, and expropriating are situations where the agent has incentives to take welfare away from the principal. And there are four different misalignments in this case that could fall under one of these. The first of them is that algorithmic designers may put less weight on the public benefits of disclosure than society does, because the benefits of disclosure are mostly externalized when private actors, if allowed to make choice about how much to disclose, when private actors choose how much information to disclose, they may undervalue the public benefits of disclosure. The second one is balancing the social cost of inaccuracy against the private cost of correcting. Different contexts will lead private actors to internalize the cost of inaccuracy to different extents. Private actor deciding how to calibrate a recidivism algorithm, for example, will not absorb very much of the cost of inaccuracy. If people who will recidivate are released and people who will not recidivate are detained, there's some reputational cost for the decision maker, but the decision maker doesn't internalize directly the cost of inaccuracy. Someone devising an algorithm for hiring will internalize more of those costs of inaccuracy. But that internalization may also not be 100%. Third, there's a social cost of bias in terms of systemic inequality and systemic discrimination that decision makers may not necessarily internalize. Non-discrimination principles under the law are not only good hiring policies, but are systemic principles that contain elements of corrective justice and distributive justice, so that even if a decision maker internalizes the cost of inaccuracy, they may not internalize fully the social cost of perpetuating systemic inequalities towards marginalized groups. And the last one, which is the one that would perhaps fall under the standard division, not under shirking, is that decision makers may also have self-serving incentives to avoid accountability. And I'm using decision makers here as a shorthand for decision makers and algorithmic designers. The reality is that the principal agent problem in different contexts could be, in one case, between the designers of the system and society, in other cases for the designers of the system and those implementing the system and society. What does it mean to have self-serving incentives to avoid accountability? It means that decision makers or designers could face liability for certain types of decisions or open themselves to a certain risk of liability for certain types of decisions, and not disclosing could limit or reduce that exposure. So, for example, if there's a company that develops in-house an algorithm for CV screening and then implements that algorithm for CV screening, and it turns out that that algorithm leads to indirect discrimination in the UK or disparate impact discrimination in the US against women, then not disclosing certain elements of that algorithm could shield the company from liability. So those are self-serving incentives not to disclose that information. So that's the framing of the principal agent problem. Why does it matter for the principal agent problem, or why does it matter for disclosure that there is a principal agent problem? Well, because error profiles can help us identify and can help us reduce the principal agent problem. So why don't decision makers or algorithmic designers always design algorithms with very low error profiles, with very low false positives and very low false negatives? Well, mostly because doing it is costly. And then there's the incentive misalignment that I was explaining just now, which is where the social costs and benefits and the private costs and benefits can be different. And importantly, a context in which deviation of incentives happen is that while in terms of accuracy and bias, socially, all errors matter, for the agent, oftentimes, only the observable errors matter. What does it mean? So imagine this case where, and this is not this done in a 2x2, but it's not a game. In this case, both the x-axis and the y-axis are decisions made by the agent. It's not a coordination game. But this is a situation in which an agent is balancing between false positives, false negatives, true positives, and true negatives in the recidivism example that I was mentioning earlier. The social concerns of the principal in this case, in a recidivism context, is first of all to avoid recidivism, so there's an accuracy concern. Second, to respect the presumption of innocence, meaning that when one risks a certain form of error, it is better to have someone it is better to have, when in doubt, someone not detained than someone detained. And there's a concern for equality in terms of reduction of racial bias that many of these systems have. For the agent, the concerns are similar, but not exactly the same. The agent wants their system to be continuously used. And the agent wants to avoid any media reports that someone, when released, committed a violent crime. So they want to minimize false positives. The agent doesn't care that much in this simplified scenario about false negatives. Every person who gets mistakenly released and then commits a crime is very costly for the algorithmic designer, because that's a very public situation where the system is deemed as ineffective. But every person that is mistakenly detained and would have not committed a crime if released is invisible. One doesn't have the counterfactual about whether someone detained would have committed a crime or not. So while both the principal and the agent in this case would rather be in a situation of low false positives and low false negatives on the bottom right, and they would both rather avoid a situation of high false positives and high false negatives on the top left, the societal utility function is so that when calibrating errors, society, or at least the social utility function would be that one would rather be in the top right corner where there are high false positives and low false negatives, but the agent or the algorithmic designer would rather be in the bottom left corner of high false negatives and low false positive. That's why the error profiles matter. So what should one do with error profiles and principal agent problems? What does it mean that error profiles intersect with the misalignment of incentives between decision makers societies in this way? Well, error profiles serve as diagnostic tools for principal agent problems. An asymmetry between error profiles can indicate an asymmetry in incentives between decision makers and society. And additionally, error profiles can always be disclosed without creating a significant concern for gaming or for trade secrecy. There is disclosure can inform the market and provide incentives for improvement, because if there's a high number of errors with regard to the chosen output variable, then that's a signal to the market to develop more accurate algorithms. And it's also a signal for entities that are auditing the decision-making process that there may be an incentive deviation. Now, these error profiles need to be estimated because it is not always obvious, or it's not always clear to what extent something is a false positive or a false negative, which on the one hand means that they're an imperfect measure, and at the same time, it means that the estimation method should be disclosed together with the error profile so that the estimation method itself is not gamed. Error profiles matter because different types of proxies and different types of error profiles lead to very different types of situations in terms of principal agent problems. So for example, high quality, once we have error profiles about a certain output variable, a high quality proxy or a high quality system with low false positives and low false negatives across different demographic groups means that principal agent problems are unlikely in that context. Gaming in that context is also unlikely because of what I was mentioning earlier, that it's very difficult to game a very good proxy. And at the same time, there's a plausible concern about trade secrecy. If someone develops an algorithm that is very accurate for a certain type of decision process, then there is a plausible trade secrecy concern that disclosing a lot about that algorithm may lead to free riding. Low quality proxies where there's a high false positive and high false negative error rate for all groups means that principal agent problems are very likely. And that's an indication that one should disclose more than just the error profile, particularly in the context that a very high false positive and false negative rate means that gaming could be possible, but gaming is not very socially costly, because gaming could reduce in the margin a proxy that is already inaccurate, but the proxy itself is problematic, not just the gaming. And it would be hard to socially justify trade secrecy because that algorithm itself doesn't have a lot of social value. And follow-on improvements may be desirable and, depending on the decision, even required. The more complicated situation is the one in which one has moderate quality metrics, not a very high quality proxy or a very low quality proxy. In this case, where there's a medium level of false positives and false negatives, or a high level of one and a low level of the other, well, the issue with non-disclosure is that it can hide principal agent problems resulting from shirking, meaning that it can hide a misalignment of incentives where the decision maker or the algorithmic designer is not internalizing all the benefits of accuracy. So the private incentives to improving accuracy are not as high as they're socially optimal. And similarly, lack of disclosure could suppress competition and prevent follow-on improvements on the system. So for key decisions where we do find a medium level of false positives and false negatives, one ought to consider alternative mechanisms for recouping investments that allow disclosure. And this could be done, for example, through other forms of IP, through tax incentives, or through other regulatory mechanisms. And one could also consider, and I'll go into detail on this in a couple of minutes, limited disclosures to, for example, government oversight bodies. Principal agent problems in this context, relevantly, are more likely when there's an unjustified asymmetry between false positives and false negatives. If we care about alignment and we care about principal agent problems, one should not think about all moderate quality proxies in the same way, but one should treat them differently depending on whether there's a medium level of false positives and false negatives that apply across the board, or there's an asymmetry and there's very high false positives, very low false negatives, or the other way around. Because this indicates a disparity in treatment between different groups. And bias is one of the elements in the principal agent problem that gets internalized the least. So what do we do with asymmetric metrics when we have a moderate quality proxy with high false positives and low false negatives, or the other way around, indicating that the algorithm works differently between groups? We should require a justification from that deviation. We should require justification for not privately investing in bias reduction, which is a cost that is then mostly socialized. That disclosure, that justification will require necessarily some sort of disclosure. That could be, for example, is the best that one can do with the data that one has, or in this particular decision, the base rate of the groups are so different that it is unavoidable to have an asymmetry or something along those lines. And if there's no feasible justification for the asymmetry, then one could require a fuller disclosure regime than just the error profiles. So that's for error profiles as diagnostic tools. And I started talking a bit about disclosure design, but there's a larger point to make about disclosure design. Disclosure design should be different depending on whether there's serious and plausible gaming or trade secrecy issues. If there are no serious or plausible gaming or trade secrecy issues, then we should regard disclosure as a default for all aspects of the decision-making process. But if there is, as there often is, a plausible trade secrecy or gaming concern, then we should move away from thinking about disclosure as a binary, where either the system is disclosed or the system is not disclosed. There are many things that can be disclosed or not. One can disclose the error profiles and the outcome variable of a decision-making system without disclosing, for example, the model, the exact training data, and the way that the model was refined after training. One could disclose the code of the algorithm without disclosing the initial data. One can disclose the data without disclosing the code. In contexts where gaming and trade secrecy issues are plausible, one needs to find ways to disclose things that do not fall into the problems that gaming or trade secrecy indicate. The outcome variable in the error profile, because of the principal agent problem, we argue should always be disclosed. And the justification of asymmetries, when they exist, should always take place. And on top of that, one can think of systems of phase disclosure. When one starts with high-level disclosures that do not bump into gaming and trade secrecy concerns, and then one from there starts giving slightly more detailed disclosures that avoid that problem. And that leads to three different questions. The first question, which I was pointing to just now, is what to disclose. One could disclose the training data characteristics without disclosing all the training data. One can disclose performance statistics. One can disclose a redacted code instead of redacting all code. And one can have a phase disclosure system from general to specific, where disclosure begins with the least risky type of information, and then it continues until there's some level of risk. But one can also think about disclosing to what audience. Disclosing doesn't necessarily mean disclosing to the general public. In some situations where one needs an accuracy improvement, then it could be possible to disclose to competitors without bumping into problems of decision subjects gaming the system. That's the opposite of what we need when the concern is rather trade secrecy and not gaming the system. Conversely, in contexts where the concern is trade secrecy, but we do not have a gaming concern, one could disclose to decision subjects different elements of the algorithm, doing high-level disclosures, not disclosures that would encourage competition, so that decision subjects do have some due process without interfering with trade secrecy. One could also disclose to the legal representatives. In contexts where there is a trade secrecy and a gaming concern, one could consider a disclosure regime to oversight bodies such as expert agencies or consumer protection groups such as NGOs. Only in contexts where neither of the two concerns are plausible, one could do a public disclosure that is more of this binary sort. And different stakeholders will benefit from different types of information. Decision subjects mostly need to know the features of an algorithm, perhaps the weights. But decision subjects cannot do much with the code or the model. Competitors may benefit from knowing the code or the model. Oversight bodies may benefit from different types of information to be able to audit. All of them will benefit from knowing the outcome variable and the error rate of false positives or false negatives. But for each of these stakeholders, it is better to avoid a binary corner solution where one feels like one either needs to disclose everything or nothing about the decision-making system. And finally, after one decides what to disclose and who to disclose it to, there's the question of under what legal regime is it disclosed? To agencies, one can disclose for independent review, one can disclose under confidentiality requirements. To the general public, one could have a system where one could disclose under other forms of IP that would grant some form of protection, such as patents or copyright. And importantly for lawyers, in the numerous situations where one faces the question in litigation about whether to disclose certain aspects of a decision-making algorithm, one can disclose under protective orders, where if, for example, someone that has been a subject of the recidivism decision-making algorithm decides to sue because they suspect that they've been discriminated against in the decision process, and that leads to a trial, then the company can be required to disclose specific elements that would actually lead to trade secrecy and gaming concerns, such as the details of all labels used, the code, the entire data source, not to the general public and not to decision subjects themselves, but rather to the court and to the attorney under a protective order that will guarantee that it doesn't get further disclosed. So to wrap up, AI decision-making tools need oversight because they serve public functions while privately developed, and because decision makers have incentives to act strategically in a number of ways regarding disclosure, which leads to principal agent problems. That means that one cannot simply leave to the market, meaning to each private decision maker, the decision about how much to disclose about these decision systems. Disclosure is a key accountability tool, not only because of accuracy reduction, bias reduction, and due process, but also because it helps us detect and mitigate important principal agent problems in public decisions. And that leads to the conclusion, for us at least, that error profiles together with the output variables that they refer to should be disclosed. They serve as diagnostic tools of principal agent problems. They do not bump into trade secrecy and accuracy concerns, and they give incentives for improving these systems. And secondly, disclosure should be thought of as a regime that has different elements that one can assemble together, not a binary where one either discloses everything or nothing. In almost every situation, a lot of elements of a decision-making system that are helpful, first of all, for detecting and reducing principal agent problems, but also for the other benefits of transparency can be disclosed without interfering with gaming or trade secrecy concerns. So that's it for the overview of the project. I'd be curious to know what you think about it, and I'd be happy to discuss anything that you may be interested in. Thank you for listening.
Thank you so much, Ignacio. And we're